They say Florida family courts are rigged against fathers, that dads never get equal time unless mom disappears or spirals into addiction. At Nest Law, we are here to put that lie to rest once and for all. You've been sold a myth. As of July 1st, 2023, Florida law starts with a rebuttable presumption that equal timesharing, 50-50, is in the best interest of the child. There is no preference for mothers. There is no presumption against fathers. The old ideas of custody and visitation no longer exist in this state. And here's the truth most dads don't hear. You don't need to tear the other parent down to build your case. Blowing out her candle won't make yours burn any brighter. What matters in Florida family court comes down to one thing. What is the best interest of the child? And the way you prove that is by showing you are not just the biological father, but an actively involved parent. Tip number 1, know the circumstances of your child. Judges in Florida are required to look at your demonstrated knowledge of your child's life. That means you should be able to answer questions like, who is your child's pediatrician? Their dentist? Their teacher? Who are their friends? What activities are they involved in? If you're truly involved, you can answer these questions without hesitation. If you can't, that silence in court can be deafening. And knowing names isn't enough. You should be able to say, when did you last communicate with these people? What was discussed? Florida courts don't just listen to what you say. They evaluate whether your actions match your words. Tip number 2, show physical safety and stability. Even with a 50-50 starting point, Florida courts must evaluate whether each parent can provide a stable environment. Your home should be safe, clean, child-ready. That means working smoke detectors, secure doors and windows, and an appropriate sleeping space for your child. And we document this. Take photos of your child's room. Document safety features. Show the court you're prepared, not scrambling. Tip number 3, provide emotional and psychological support. Florida law looks at each parent's ability to support the child emotionally, not just physically. Create an environment where your child feels heard, has structure, has consistent routines. Document the little things, bedtime routines, chore charts, journals of meaningful conversations. These details matter more than most fathers realize. Tip number 4, be actively involved in school and healthcare. Florida courts prioritize parents who are engaged, not passive. Are you helping with homework, communicating with teachers, attending school events, managing medical and dental care? Save emails with teachers. Keep appointment reminders. Document extracurricular activities. This is the kind of competent, substantial evidence judges rely on when evaluating timesharing. Tip number 5, encourage family and a unified front. Florida law specifically evaluates whether you encourage a close and continuing relationship between your child and the other parent. Yes, even if your relationship with your ex is difficult. That means encouraging time with grandparents, extended family, important people in your child's life. Your messages matter too. A simple framework works. State the issue, explain the plan, ask for input. Even if the other parent never responds, those messages show the court that you're reasonable, child-focused, and cooperative. Tip number 6, be financially consistent and prepared. Florida child support is calculated using a statutory formula based on each parent's net income, the number of overnights, health insurance, and childcare costs. You must submit a financial affidavit, and inaccuracies can seriously damage your credibility. You don't need to be rich, but you do need to be consistent, transparent, and prepared. Pay stubs, work schedules, and a child-focused monthly budget all help demonstrate responsibility. Tip number 7. If you've been absent, it's not the end. Some fathers worry because they've been away, military service, work obligations, being kept out of the child's life. That does not disqualify you. It means you need to work harder to show commitment. Take the mandatory Florida Parent Education and Family Stabilization course immediately. Consider additional parenting or conflict management classes. Take notes, write reflections, be prepared to explain what you've learned. Winning a fair parenting plan in Florida isn't about being perfect. It's about being prepared. It's about knowing your child, understanding the law, and showing the court through evidence that you can meet your child's needs.